Welcome to Ask a Lawyer with attorney Joey Franks at the Franks Law Firm in Ridgeland, Mississippi. Each week, Joey answers your questions about the law and how it affects you.
If asked to take a field sobriety test, what do I do?
Well, you have a couple of options. You're not required to do a field sobriety test. And by refusing to do the field sobriety test, that is not the test they are looking for a refusal charge. A DUI refusal charge is separate from a DUI first, second, or third. They are looking for a refusal of the big intoxilizer machine, usually at the police station. Now, my advice would be don't do a field sobriety test because these tests are designed for people to fail. They are very confusing. I've had an officer perform one on me in a setting that was perfect level ground. We had a clear line and I just wanted to know what my clients were going through. And I failed the field sobriety test and I was sober as a preacher. So I always tell clients, do not perform a field sobriety test. It just gives them ammunition and it almost never helps my clients.
Let's say I've agreed to it and they ask me to follow an object with my eyes. What are they looking for?
Well, the test they're performing in that situation is almost certainly the horizontal gaze nystagmus. And what they're looking for is wiggling of the eye, essentially, is the simplest way to put it. It'll have an involuntary movement to it if somebody is on depressants, which doesn't necessarily mean alcohol only, but and oftentimes it's what it's used for since alcohol is a depressant. But that's the test that's being performed there. Other tests that are performed where there's an object held, or some officers will use just their finger, that is getting into more drug-related impairment as opposed to alcohol-related impairment. And those officers have to have certain qualifications for those tests to be valid.
Okay, so what happens, and you mentioned, don't take the test. What happens if I refuse to take the test?
Most likely they will have you standing outside, either at the front of your vehicle, the rear of your vehicle, or possibly by the patrol car. And they will offer you that test multiple times. Rarely is it an officer that'll just say once and throw you in the back of the car. And they still have to prove impairment beyond a reasonable doubt. And those field sobriety tests just help them with it. Now, they've probably also offered you an intoxilizer. A breathalyzer, excuse me. Intoxilizer is the big machine at the station I mentioned earlier. The breathalyzer is these portable breathalyzers that officers carry around in the back of their patrol cars, rattling around with the tire in the back. If you refuse those, there are no penalties. You will likely be taken to jail. And at the jail, you will be given the option to blow on the intoxilizer. Until you refuse to blow on the intoxilizer, you will not be charged with a DUI refusal. If you are charged with a DUI refusal, then you would have very good grounds to file a petition for a breath test refusal hearing, in which case you would likely be successful.
So I can refuse any kind of test, even if they take me to jail, I can refuse a test there?
You can refuse every test offered to you, but as I mentioned, that brings up an entirely separate charge of DUI refusal, which results in an automatic suspension of your license for 90 days. And the process for that is the Department of Public Safety will mail you a letter to the address on your license. And that's key because a lot of people move and they forget to go and update their license. And you have 10 days to file that petition I mentioned with the county court in your area or the circuit court, depending on the county, and set that in for a judge to determine whether or not a breath test refusal occurred. If the officer never offered it to you at the station, that's the one that counts and no refusal occurred.
Okay, let's say I didn't get my Miranda rights read to me. Can my case be dismissed?
That is a question that I am asked very often. I'm glad you asked it, Steve. Actually, dismissal of your case is not the remedy for failure of an officer to read you your Miranda rights. Miranda rights are read to an individual when they are placed under arrest. And at that point, you are informed you have the right to an attorney. You have the right to remain silent. We've all seen the law and order spiel that's given. But The remedy for not reading someone their Miranda rights is anything that individual says in custody from that point on cannot be used against them in a court of law. So if the officer doesn't read you your Miranda rights, they book you, they take you to the jail, and as you're riding with the jailer, you say, I was drunker than Cooter Brown. Well, that's probably going to be excluded from any kind of testimony at court if your Miranda rights were never read to you.
Thanks for listening to Ask a Lawyer with attorney Joey Franks at the Franks Law Firm in Ridgeland, Mississippi. Call attorney Franks for a free consultation at 601-773-7777. His website is thefrankslawfirm.com.